principles of sentencing set out in the legislation. Principles and purposes of sentence are set out. Again, the sentence is to be the least restrictive measures, taking into consideration the seriousness of the offense, the harm occasioned to the victim or the community, the specific role of the young person in that offense. Was it the primary role? Was it the secondary role? What was that role? And then with those considerations, again, a sentence that is most likely to affect the rehabilitation and reintegration of the young person back into the community. There are unique sentences in the youth criminal justice system that don't exist in the adult system. One is a reprimand. Essentially, it's an admonition by the judge to the young person not to reoffend. And it is important because on a reprimand, which follows a plea of guilt, the record for the young person for that offense is erased 60 days after the finding of guilt. Again, as if it hadn't happened. It is used by judges. Sometimes there's a delay before the matter gets before the court. The Crown insists that there must be a finding of guilt, and it is their prerogative to bring that before the court. And if the young person acknowledges responsibility and pleads guilty, it may have been some time since the offense, and the young person may have, in that interim, again, harken back to the time of to the defense counsel having engaged the young person in programming, school, counseling that establishes and affirms the young person's pro-social perspective, that the court looks at the young person at the time of sentence and realizes that no further process is necessary. So there's an example of when a reprimand might be used. The other one is to address Crown discretion as a gatekeeper. And again, I'll give you an example from my experience. Young woman, 15, 16 years of age. She, again, tragically had been terribly abused as a child and removed from her family. Despite the abuse that she had experienced in that family, it was the love that she knew. And so she had a tendency when she was in Children's Aid Society placements, and they tried many, to run back to her family. And of course, that wasn't appropriate. So she would be apprehended and then placed again. Well, in the course of one of those apprehensions, when she'd run back to the family, she was extremely upset and she lashed out. And so she was charged with assault. There was no injury, but she was charged with assault. And the Crown determined that it was that she had to acknowledge her responsibility. And there had been a number of incidents before that could have resulted in charges and had not. So the Crown determined at this point that yes, they would exercise process and that she would be in charge formally with assault and brought before the court. She was released immediately on bail because she really there was no injury, and she had a very tragic background. And she was released always with the same condition, and that is to reside where directed by the Children's Aid. Well, she kept running. The fact that the court was saying to her that she shouldn't run just in the impulse moment didn't have effect, and she would run and she'd run back to her home. And it wasn't hard to find her. Police would generally find her either later that day, or if she was in an outer jurisdiction, that is, in another part of the province, it might take her a day or two to get back home, but she would be there. And the police would go and find her and bring her back before the court. She would be charged with failure to comply with her bail release and then released again. Well, so the result was that when the matter came before me and she wanted to acknowledge her responsibility for assault, and the Crown, very empathetic, remarkable woman, Crown, suggested to me a reprimand was the appropriate sentence. And I said, well, that's fine. But what about all of these other charges? She said, well, I have 6 charges of failure to comply in my jurisdiction, and I'm going to withdraw those if she'll, on the plea of guilty to the assault and with the sentence of the court. But the other charges were still outstanding. And I said, well, let's see if we can get all those charges from all the other jurisdictions in Ontario brought before this court so we can clean up everything. And then when she leaves the court, she has no other charges. And that was deemed to be a good idea. The difficulty arises because Crowns in other jurisdictions, when they waive a charge into another court for resolution, they can provide that Crown in that court with discretion as to how to deal with the charge. But the Crown also has the power and right in that external jurisdiction to dictate that they wish the young person to acknowledge responsibility to the failure to comply in that case or the charge by a plea of guilty. So we had, I'm trying to remember, I think there was some total of 30 failure to complies, of which 6 or 7, as I indicate, from Toronto were being withdrawn. So of the remaining 20 odd, my recollection is that about half of them, the Crowns were insisting that there be a plea of guilty. Those are Crowns probably with very little knowledge of the history and the tragedy of the young person before the court, and also versed mainly in the adult system where it's required that you acknowledge your responsibility by way of plea of guilt. So the transfer was allowed, but on the condition that there must be a plea of guilty. So the Crown in Toronto, amazing person, let me understand that. And because I practiced in the area for some 30 years, I certainly understood that issue. So there was a use of a reprimand. Sure enough, for those 10 or 12 charges or whatever that the young person had to plead to from other jurisdictions, I granted a reprimand in each one. And that meant that the record was only going to last for 60 days and it'd be over. So it was a way of addressing that silliness, if you like, in terms of the discretion and the way it had been exercised by some of those Crowns. Probation, as I indicated, is a sentence, and again, within the parameters can only be 2 years. And there is no provision other than 2 years. Probation is an absolute, can only be for a maximum of 2 years. And there is an admonition in the legislation for the court to consider conditions that can allow for compliance and not immediately set the young person up for failure. For instance, a young person who seems to have a dependence on marijuana is a good example. To order that young person not to smoke marijuana, it's not going to happen. I mean, it's going to happen in the next few days probably, or within a week, or maybe within 3 weeks of that probation being imposed, that they're probably going to smoke marijuana again. And so they're back before the court on the failure to comply. It's just an unreasonable term. Certainly appropriate to have a condition that the young person attend for counseling to address that issue and why it is that they have that dependence on marijuana, because it likely is rooted in a deeper psychological issue. But that's totally appropriate. But to just make a blanket statement that they're not to smoke is just to invite that there's going to be a breach. And in fact, it's already the law. So it's not necessary to make it as a term of probation. It can be left to the discretion of the police officer or the Crown, depending on what the circumstances are in which they find the young person using marijuana, as to whether they even want to charge them. There is an order known as an intensive support and supervision order. It's essentially super probation. It allows for, it's an alternative to custody and noted as such in the legislation. Concept is that monitoring the person maybe once every 2 weeks by a probation officer is not sufficient. This individual, because of their presentation, needs to be monitored more closely, perhaps once a week, maybe even twice a week, initially, to make sure that they're in compliance. And that can be very valuable. Attendance, there's a provision for an attendance order. A court can order a young person to attend at a particular program, be it vocational, academic, recreational, athletic, if it seems appropriate, obviously, taking into consideration the profile of that young person. The maximum period for an attendance record is 6 months or 240 hours, but it can be very supportive. Very supportive for a young person who might be struggling a little bit with school because they don't have support at home in terms of homework. So the order can be that they attend at a facility that supports homework after school, which then again will address success for the young person in the academic program. There is a provision for a deferred custody and supervision order. In the adult system, it's called a conditional sentence. In the youth system, again, alternative to custody, it allows that the young person, there's a maximum of 6 months for it, allows that the young person can essentially serve a custodial sentence in the community. So they're at home, maybe rather limiting conditions as to how and when they can be out of the home, because it's the seriousness of the behavior that brought them before the court is such that it's important that their activity in the community be closely monitored. It's not available for charges of assault, bodily harm, or attempting bodily harm. And a breach of that order can result and probably will result in custody. First-degree murder is a sentence under the Youth Criminal Justice Act. First degree is premeditated murder. And in that case, under the youth system, the maximum sentence is 10 years, 6 years, up to 6 years to be served in custody, and then up to 4 months or 4 months of conditional supervision. Second degree murder, a maximum of 7 years under the youth criminal system, 4 years of custody, 3 years of conditional supervision. And then there's another unique sentence, that is the intensive rehabilitative custody and supervision order. Extremely rare and funded by the federal government for particular cases, cost being certainly in excess of $100,000 a year per young person. It's available for murder, attempt murder, manslaughter, or aggravated sexual assault. It is an alternative to conventional custody for those youth diagnosed with mental or psychological disorder or emotional disturbance, with an individual treatment program that's been developed and is available, and for which there are reasonable grounds that believe that the treatment plan might reduce the risk of reoffending. Important to note that the young person has to consent to this sentence. The very important principle of consent persists throughout the legislation, and treatment for a young person cannot be done without their consent. Adult sentencing. Well, I mentioned that before. Now we're at adult sentencing. It is on application by the Crown. Youth must be 14 years or older, and in some jurisdictions, the province can make that age for which an adult sentence may be applied for higher. Might be 15, might be 16, but the basic legislation provides for 14, can't be younger than 14. It is only for serious offenses. Again, offenses that for an adult would allow for a sentence of in excess of 5 years. The Crown must give notice at the very commencement of the proceedings against the young person that they intend to seek an adult sentence. At any time in the proceedings, the Crown can change its mind and say that they're no longer seeking that adult sentence. But if they are going to seek it, they have to say so at the beginning of the proceeding. Young person is then given an election. They can have a trial in the Ontario Court of Justice, which was the court I was in, and that's without a jury. Or they can have a trial with a jury or judge alone in the Superior Court. And then that would allow for something called a preliminary inquiry, which is part of the adult criminal system. Invariably, a young person is, well, not invariably, but many times, a young person is going to elect to be tried by a judge of the Ontario Court of Justice. And the reason for that is that the Ontario Court of Justice judges are, all of them, virtually all of them, have practiced criminal law before they were appointed. So they're specialists. They understand the law. If you want a jury, then you would elect to go to the Superior Court. But if you're looking for a judge alone, in the Superior Court, you have brilliant jurists. But in their experience as lawyers, they may have spent their career doing construction liens. They're not experts in criminal law. So if there are criminal law issues to be determined, you're better off probably in the Ontario Court of Justice. And so a number of murders were tried in the building I was in. I did a couple of them. And for that very reason, because the Crown was satisfied. The Crown, by the way, does have the option, if the young person elects to be tried in the Ontario Court of Justice in front of a judge alone, the Crown can ask that the matter be transferred to the Superior Court for a trial with a jury. But even in that case, the protections and procedures that pertain to young people are continued in that different court. The hearing as to whether a young person should be subject to an adult sentence is held after a finding of guilt. Under the Young Offenders Act, it was a transfer hearing before the trial, and the Crown was able to rely on what they said was their best evidence, which hadn't been tested and couldn't be tested at that stage. And so there was a strong presumption for transfer. In this case, now the court actually knows what the facts were upon which the young person was found guilty. And then at that point, the determination is as to whether an adult sentence should be imposed. The Crown has the onus to establish and rebut the presumption that youth have diminished moral culpability, and that a youth sentence would not be sufficient to hold the young person accountable for their criminal behavior. That onus is on the Crown. And if they can't establish that onus, then the sentence remains to be done in the youth system. One of the most remarkable, there are two really remarkable provisions in sentencing. One is when the sentence is going to commence. Doesn't exist in the adult world. So in the youth world, a judge can determine when a sentence is to start. And it can be extremely important to take consideration of school, vocational programs, employment, not to interrupt something that's extremely supportive and meaningful to the young person in such a way that they're going to lose that opportunity, which of course will result in perhaps wrecking their life. So that's a very important principle, and I'm going to give you a case that I was involved in, which show you how that can be used in a practical sense. And the other one is review of sentence, and I've touched on that before. The review is by the sentencing judge, unless that judge is not available due to illness or has retired. If the sentence was one in excess of 1 year, it is mandatory that a review be conducted at 1 year, mandatory. And prior to that, at the discretion of the court, if the sentence was less than a year, at 1/3 of the sentence, or again at the discretion of the court for earlier time. Very important. On review, a judge cannot make the sentence more onerous. The judge has the option of either affirming the original sentence or rewarding the young person with for good behavior and compliance by reducing the sentence. This is a remarkable tool in the system to admonish and encourage young people to rehabilitate themselves and to reintegrate themselves into the community. Used virtually every time we imposed custody at my court at 311 Jarvis Street, and very often for non-custodial sentences to reduce the conditions and to reward the young person for compliance by taking away some of the conditions that they were expected to follow. It can reduce the time when the sentence is changed and a lesser sentence is imposed. It can reduce the time that the record for that young person will persist. And as I indicated, a great incentive for compliance. Example. Seven young men engaged in a very sophisticated robbery of a money mart, money exchange facility. They planned it carefully. I should say, well, 7. 2 of them were brought in at the very end, and the Crown's perspective was that it be non-custodial for those 2. For the other 5 that were engaged in deliberate planning and very careful planning, the Crown was seeking appropriately custody sentences. They essentially researched it by taking observation of the money mart over the course of a number of days. The money mart was operated by a man and his wife and the husband's brother. There was a faith issue here in that the males attended for prayer on a number of occasions during the day. And the observation was made that at those times, the wife was left isolated and alone in the money mart. And so they determined that they would engage in the robbery when she was isolated. So that really strong deliberation and planning. They phoned the day in advance to make sure they wanted to access $30,000. They phoned in advance the day before to assure that the money was in fact going to be there. They'd asked for it and they were assured that it would be there. That was the classic mistake because they used the cell phone of one of the young person's fathers. And it eventually allowed the police to unravel this plan. In any event, robbery took place. Woman was isolated. She was taken into a storeroom. She was gagged. She was gagged and tied. The young persons were masked. They had imitation firearms, but from the perspective of the victim, she wouldn't know that they were imitation. She was terrified. She really thought that she might be losing her life. The money was taken. Investigation started, and as I say, with the finding of that cell phone number, which was used the day before to confirm the money being there, eventually it unraveled, and eventually all 7 were arrested. I'm going to deal with two of the young people who were sentenced because they provide a classic example of how the system can work to an advantage. One of them was 17. I was sentencing in November, and he was 17. He had been admitted to Dalhousie University in Nova Scotia to commence in the January term, which I believe was starting in the 3rd week of January. And his parents were moving to that community. His father was a senior manager in a financial corporation and had been transferred. So it was a very supportive situation. The young person had to complete an English credit. And on completion of that English credit, that he was virtually finished on, the exam was in December, he would be admitted to the university. The other young person was 16. He was gifted athlete, student leader in his school. Neither of them had any record. Both of them had been pro-social up to that point. And that individual, the 16-year-old, was in a very specialized program at a particular high school in Toronto that allowed that upon completion of the program in grade 12, the young person was guaranteed placement in a highly sought-after apprenticeship program. Guaranteed. So, sentenced them in November. They had to have custody, and I determined with the pretrial detention that they'd had, because they'd each had, I think, 2 or 3 months of pretrial detention, that the sentence, again, on the basis that they had been totally compliant with their bail conditions and had shown pro-social behavior since the offense, that the sentence would be 9 months of custody, followed by, I believe, 12 months of probation. The 9 months of custody and supervision would be 6 months in custody, 3 months in community supervision, followed by probation. So what to do? I placed the young man that was eligible to go to university on probation as of the day of sentence, and I told him that he was going to surrender himself for custody in the second week of January. But I also suggested to his counsel, and we organized, that he would come back for a sentence review at the end of the first week of January. When he came back, he completed his program. He'd done very well in his English credit. He had confirmation of the fact that he was admitted to university in Nova Scotia. And I changed the custody to conditional community supervision so that he could travel to Nova Scotia. We transferred the probation and brought him back. I told him to come back and see me at the end of that academic term, which would have been at the end of April. He came back at the end of April, had done very well in his first semester of school, and I changed the remaining part of his community supervision, which had been part of the custody order, to probation, and allowed him to be on probation for the rest of his sentence. The 16-year-old, I looked at him and I said, okay, well, here's the deal. You're going to come back. I'm placing you on probation from now, November, through to the third week of June. And you are going to surrender yourself upon completion of your program at the second week of June into custody to serve your sentence, to start then to serve your sentence. But I want to see you. I want to see you at the end of the first week of June, and you're going to tell me how you've done. And so when he came back, he'd completed his program. He'd excelled. He was an A student. He had continued to show leadership in his school. So I rewarded him. I changed his custody to community supervision and told him to come back and see me in October when he was in his apprenticeship program. And when he came back in October and was excelling in that program, I changed the community supervision to a probation order to allow him to continue with that program. So there's a classic example. The legislation admonishes all those in the system to be creative. It's an example of how one can be creative to make a statement, in this case, an important statement of custody, but at the same time not destroy a young person's life.